Good morning, Your Honour. If it pleases the court, my name is Wood, spelled W-O-O-D, initial K, and I represent the plaintiffs, George and Fran White, against the defendant, Bank Limited. I am instructed by trusted solicitors. Your Honour, my clients are seeking an injunction against the defendant in regards to the sale of their house. This is being sought on two grounds. Firstly, unconscionable conduct, and secondly, undue influence. Looking first to the issue of unconscionable conduct, the elements of unconscionable conduct in relation to equity are as follows. That A, one party is in a position of special disadvantage or disability, and that B, the other party knew or ought to have known about this disability and or disadvantage and has taken unfair advantage of their position. It is submitted that my clients were in fact at a special disadvantage or disability on the grounds that Mrs. White has recently suffered a mini stroke and was preoccupied caring for her ill sister. In regards to Mr. White, he is noted as having lower than normal intelligence and allows Mrs. White to handle all financial matters relating to both of them. Thus, both of my clients were at a special disadvantage. In Bloomley and Ryan, 1956, page 99 of the Commonwealth Law Reports, volume 362, as noted by the trial judge, that special disability should be considered far more broadly than merely a physical or mental disability. That is, illness, illiteracy, poverty, sickness, a lack of education or intelligence, among other things, is more than sufficient grounds for special disability. This is further supported in the case of Luth and Dispers, 1992, page 145 of the Commonwealth Law Reports, volume 621. In this case, even emotional dependence was deemed as a special disability. It can clearly be established that my clients were in fact subject to sickness on the part of Mrs. White. Also, given the nature of the sickness, it is more than reasonable to allow for the effects of cognitive decline related to this. Furthermore, a demonstrated lack of education on the part of Mr. White places him at a special disability as well. In relation to the second element of unconscionable conduct, where one party either knew or ought to have known about this special disability and has taken unfair advantage, this can also be satisfied. Mr. Rob White, the plaintiff's son, who was the original person seeking a loan from Bank Limited, was using his parents' home as a guarantee, as he lacked sufficient assets to secure a loan on his own merit. Mr. Rob White was aware of his mother's recent health conditions, as well as his father's lack of general education and his mother handling finances, and deliberately deceived them in regards to the amount and duration of the loan. Bank Limited has taken no action to ensure that my clients were aware of the true amount or the duration of the loan, nor their responsibility for which they bore in the event of their son's defaulting. The case of Commercial Bank of Australia, Proprietary Limited, and Armando, 1983, page 151, the Commonwealth Law Reports, volume 447, contain a very similar set of facts to this case. In that situation, parents were signed as the guarantee for their son's loan. Mr. and Mrs. Armando were originally from Italy and spoke very little English. Their son was a businessman who persuaded them to sign over their home as guarantee for security on a business loan. He also misrepresented the amount and duration of the loan. As a result of their illiteracy and poor language skills, the court held that they were at a special disadvantage in regards to making decisions in their own financial interest. It was also found that the bank was acting in an unconscionable manner. It is noteworthy in this case that the loan officer in question did at least make a token effort to clarify some details regarding the loan to Mr. and Mrs. Amandio. And the bank's conduct was still considered unconscionable. No such effort was made towards my clients in clarifying their understanding on the amount or the duration of the loan. Moving to the issue of undue influence, we submit that given the nature of the relationship between my clients and their son, which under Class 2, this would be considered a recognized relationship of influence, that of parent and child. However, the facts in this case indicate an opposite power dynamic than one would generally be recognized of that by the courts of the parent and child. We submit that the client's son, who has styled himself as a successful business owner, compared to that of his retiree parents of ill health and low education, as having more power in this dynamic. This would constitute a Class 2 relationship, where there is a presumption of influence. And this is also described in Elkhart and Skinner, 1887, page 37 of the Chancellery Division, volume 145. Similarly, in the Bank of New South Wales and Rogers, 1941, page 65 of the Commonwealth Law Report, volume 42, there was a special relationship that existed between a young woman and her uncle. Onus was placed on the bank to rebut this presumption of influence and establish that the young woman, in fact, knew what she was doing and understood the circumstances of the contract, and that she signed freely without the influence of the special relationship. Obviously, the bank could not establish these facts, and she did not understand the circumstances, nor was she done without influence. This matter was then set aside. In regards to this case, given the fact that my client's son expressly lied to them about the amount of money the loan would constitute and the duration of this loan, it cannot be established that my client understood the circumstances of this contract, regardless of their own not reading it. Also, given the desperate financial situation with which my client's son found himself in, and the recognized influence of the special relationship that existed between my client and their son, it also cannot be argued that the influence had not been exercised over my clients. In Johnson and Buttress, 1936, page 56 of the Commonwealth Law Report, volume 113, the facts in this case are very similar to that in the present matter. It concerns an elderly man of low intelligence who routinely sought business advice from others and who transferred ownership of the land on which his property resided to the defendant, who was a family friend of his late wife. It was established that a special relationship existed between this old man and the defendant in whom he trusted, therefore placing the onus on the defendant to rebut this presumption, which they could not. My client, Mr. White, is also noted as having lower than average intelligence and places financial responsibility solely on his wife as a result. Yoakley and Jones, 1937, page 63 of the Commonwealth Law Reports, volume 649, states that the relationship of husband and wife is generally not considered to be one where a special relationship can exist. Therefore, it is argued that a special relationship was present between my clients and their son, and undue influence has been exercised over them. We move that an injunction be filed on behalf of the plaintiff to prevent the sale of their home on the grounds of unconscionable conduct and undue influence, as previously supported by the earlier submission. Thank you very much for your time, Your Honor.